Let me start by doing traditional acknowledgement to country by acknowledging the fact that today we meet on Gadigal land, and I pay my respects to Aboriginal land, elders past, present and emerging. For those of you that haven't met me, I'm Olga Ganopolsky. I have the privilege of being the chair of the Privacy Law Committee. I am the General Counsel for Privacy and Data for Macquarie, our host today. And I say this with some pride and I suppose personal involvement by saying we're sold out today and welcome. I want to start with a thank you, because we often do thank yous at the end after all the big discussions have happened. So I genuinely want to extend a thank you to everybody who made the seminar possible, the seminar about to unfold. That includes obviously the members of the BLS Executive, the Law Council, members of the Macquarie team that have put so much effort into organising the event and making it look beautiful and coordinated as it is today. But I especially want to thank the three commissioners who are going to spend some time with us today unpacking what is a really complex area of both privacy and freedom of information law. And the two, while they're different, are actually very, very connected. And we'll talk about that in a minute. The reason I want to start with a thank you and blend the welcomes into that is because today's seminar marks also a very special occasion in that we, as the legal community, as the Law Council, have an opportunity to thank Commissioner Falk, Angeline Falk, for her tenure, 2 lots of tenure as the Commissioner, Privacy Commissioner, and then the head of the OAIC as the Information Commissioner. And this will be her last official appearance in that capacity. So enormous gratitude and thank you for the collaboration, for the leadership, and for the development of the law and practice in this area. And I want to stress that while there have been important developments in the law, just as important has been the practice. And I think the collaboration with the regulators really sheds light on that practice, transparency, and then actually reinforces what the Law Council is about, the rule of law, and how it's to be developed in a consistent, transparent manner. So thank you. It is also a really important opportunity to do a welcome. Welcome to 2 new commissioners who very conveniently started in February. So we don't need to dwell on the start dates. So immediately to my left is Commissioner Kylie Kind, who is the Privacy Commissioner. And right to Angeline's left is Elizabeth Tidd, who is currently the Freedom of Information Commissioner and will take up the Information Commissioner post very, very shortly. So welcome and congratulations on what are really significant appointments in the 3-commissioner model and the way of the future. We will spend a great deal of time talking about the future, given the nature of privacy, FOI, and the impact that it has on developments in technology, developments in human rights, and developments in administration of the law generally. Before I then move into the content and the structure of the session, I do want to acknowledge that the session is sold out, and for the benefit of those broader members of the profession and the privacy community, the session is being filmed. And so this announcement serves dual purposes: transparency, notice, it's being filmed. I also want to acknowledge all of the members of the profession that are here, members of committees, chairs of those committees, and the work that's being done to put seminars together, make submissions, and develop and elaborate on the law. So what is this area of law about, and why are we talking about privacy and FOI together? We're going to discuss this question today with the benefit of a seminar style with our esteemed guests. And the structure of the seminar is very simple. I'm going to spend a couple of minutes setting the scene. Then we're going to launch into a discussion of what is the current law and practice and what is the future. And as many of you will know, the last 10 years have been really substantial changes in privacy law and FOI practice, not least of which are enormous developments in the expansion of the credit reporting system, the increased penalties and fines and the powers that the regulator have to issue those fines and how they're administered. We've had sizable data breaches and sizable investigations that have also shed light on what's important and some of the ways that the law is to be practiced and applied. And probably just as importantly, we stand again on the precipice of change in the next 10 years as we await the law reform process to unfold in the privacy review. I also want to make a point that as we discuss these matters, we have a strong international presence in the discussion that is privacy and freedom of information. And when I say that we stand on the precipice of change, I should underscore that while we're here in Australia, as practitioners in Australia, the precipice of change is also with our nearest neighbours. Practically every jurisdiction to our north, the south is a little bit more developed in terms of New Zealand, has implemented either GDPR style or similar comprehensive reforms. And when I say GDPR style, it's important to note that they have clearly borrowed from the extensive and very established jurisdiction and high watermarks in Europe, but they're different. And we're talking about billions of people in China, in India, coming within scope of comprehensive privacy reforms and the change that that brings, again, in law and practice, given the international nature of privacy and freedom of information. What makes it international, I think, is the genesis that it has in human rights. And our commissioners here today will also bear some of that connection and why that's very, very important. So as we commence this discussion, as we move this discussion, you've all had the benefit of the invitation and the extensive experience that the commissioners have in administration of either privacy or information rights law and freedom of information, all stemming back to openness of use of data, responsibilities for the use of data, be that in government and agencies or be that in private practice. And I think that synergy is very, very important and creates quite an important dialogue. So I won't go through the detail of those enormous achievements that are collectively represented here. They are clearly articulated in the bios and in the materials that are part of the invitation here, but they are extensive and international. So Commissioner Kind, with her experience in Europe and the work with the Ada Lovelace Institute, as well as earlier in the European Commission and some of the NGOs leading with a human rights spirit. We also obviously have the extensive experience of Commissioner Tidd, given the previous experience as the New South Wales Information Commissioner and the enormous body of work that was done on open and transparent government and some of the learnings that have arisen out of that and what lies ahead. So that's our structure, the context, and then the subject matter of the law. And as I said, a large part of what will happen today is just an acknowledgement of what happened in the last 10 years under Commissioner Falk. And I should underscore that while we talk about the last 10 years as Commissioner Falk at the helm, the career that spans privacy started all the way back in 2007. So I think we'll hear some important references in terms of both the law as it is now and how it operated in the last 10 years, but also the genesis and how that area of practice works. So that is kind of enough from me at the moment, in that I'm going to take a seat, and really all the hard work now moves to our three commissioners, and I get to have the privilege of asking some of the questions and hopefully not participating in too many answers. And then we will return to really you, the audience, the participants, and give the profession an opportunity to ask some questions and make some comments, and then move to a close. So without any further ado, welcome again. And as you can see, kind of the floor is yours, and I get the opportunity to, I suppose, lead with kind of the first question and come back to the comments that were made about human rights. And this is really a question to all three commissioners here today. Maybe we start with Angeline. Like, how do you see the administration of privacy and freedom of information and the footprint that the OAIC has had over the years and the human rights mandate that it's had?
Thank you, Olga, and wonderful to be here, and great to see so many known colleagues and new faces as well, and such incredible commitment to this area of practice of the law. We need good practitioners in access to information and privacy. I'm glad that we're starting with the whole concept of human rights, because it's the foundational principles of both access to information and privacy regimes in Australia. And it underpins both individual rights and also collective rights, and goes to the heart of our mission at the OAIC to promote and also protect information access and privacy rights. In terms of information access, the FOI Act makes really clear that information needs to be treated as a national resource that government holds for the benefit of the public. And so therein is a representation of our collective right and interest of the accountability of government and our democratic institutions. So too our right to seek and receive information is an individual right that's recognised in international treaties and conventions. And in terms of privacy, again, it's an individual right, our right to be left alone, to be free of unlawful intrusion or unnecessary intrusion, our right to decide to whom we disclose and what we disclose of ourselves. So really it goes to what it is to be human, and our ability to exercise autonomy and control over our humanity. And in terms of how that then operates at the OAIC, you see that in terms of how we handle individual complaints and individual rights, and then also our efforts to address collective rights and interests in the public interest. And that's the work that we do on Commissioner-initiated investigations, and looking more systemically at issues that might create greater societal risks and harms.
I think that's a very comprehensive answer. Maybe we give Carly an opportunity to chime in, given that privacy is so obviously connected to human rights and the work that you've done prior.
Absolutely. I mean, Angeline's answer was very comprehensive, but I would just contribute to that, I suppose, by underscoring that my own kind of journey into privacy came very much through my experience of living and working in Europe, and therefore I came to know privacy as a right first and foremost, and having worked in human rights prior to that. And under the European framework and under the European Charter, privacy is actually divided out into two rights. There's the right to privacy and then the right to data protection specifically. And I think that really helps to underscore how critical information-related rights really are to the enjoyment of other human rights. I think we've seen that recognition then kind of spread across jurisdictions, and certainly having returned to Australia, and despite the absence of a national human rights framework, I find it very clearly resonates with people that it is a human rights issue. People feel that instinctively, even if perhaps the legal framework in some respects doesn't necessarily recognise it in that way.
Elizabeth, are there any particular nuances in freedom of information that call out slightly different aspects?
I think there's the issue of structure. Why are we co-located? Why are you seeing three commissioners here today represented and speaking about the commonalities as distinct from the tensions that might arise? So not only is there a nexus with the legislation, with APP 12, access to information and the right of access to information under the FOI Act, but there's also a reflection of the fact that these are two fundamental human rights, as Angeline has pointed out, and they don't always have to be in conflict, but they do always need to be considered equally. And one of the aspects that we deal with as the regulator is that we're working with government agencies and with industry on that intersect. And where we show leadership in how that intersect is successfully achieved, it's easier for compliance by particularly government agencies, but government agencies in dealing with industry, when there is a contract, government expects those rights to be upheld. So our expertise in balancing those rights and in both regulating the government sector as well as industry brings us a particular expertise and vantage point to make it easier to achieve compliance more broadly. So I think seeing us as a complementary three commissioner model is something that's really important in terms of actually administering those rights.
So it's a consistency and also the harmonisation question. Yeah. Angeline, just referring to the two-term period. Have you seen that change and shift, or do you think that's a sort of a stable question that just being reinforced? What's your perspective on this?
I think over time it ebbs and flows as to the emphasis that human rights is given, particularly in the data protection context. And there's probably been, over the last 6 years as Commissioner, a recognition of both the economic interests that drive data protection and also the human rights aspect, and that the two need to work in harmonisation. That we are about ensuring responsible use of technology, that we can have data-driven economies that protect human rights at the same time. And it's getting that balance right that I think has been the challenge over the last 6 years. And we've seen that as an area of scholarship for academics. We've seen it as an area of co-regulation across our economy with ACCC and their digital platforms inquiry and subsequent reports, with the E-Safety Commissioner, with the ACMA and also the OAIC. So what I've seen over the last 6 years is the need for regulatory convergence to protect both human rights and economic interests, and the need to ensure that we're doing that in a considered and really joined up way. And that's one of the things that I'm pleased we've been able to do, particularly over recent years, is to have that regulatory convergence happening not only at the domestic level but also globally with our work with the Global Privacy Assembly, and also working with our international counterparts in consumer and competition protection.
It's interesting that in all of the kind of comments so far, you've all touched on the three commissioner model. Do you want to just articulate how important that either novelty or the return to the original model is, and what significance that plays in the structure of the office?
Yes. It's a great pleasure and honour for me to be finishing my term with the three commissioner model returned, and to have such exceptional leaders who have taken up these positions. I of course wish that there was more time to see what we could deliver together, but I feel so honoured and privileged and also confident in the way in which information access and privacy rights are going to be regulated into the future under these commissioners. The model itself, just to recap, it has the Information Commissioner as the agency head, who's responsible for setting the strategic direction, who also has specific information management functions for government, so looking at how government is handling information more broadly. And I think one of the things for me, having just had this 5-month opportunity without the other responsibilities, is to see how the intersection between privacy and access to information can really be enlivened through the single Information Commissioner role. And we see that there's been many developments across government around data handling. If you think of the National Data Commissioner, that's about sharing government information for public good. The Information Commissioner has a statutory role to play in advising that commission. So it's really bringing to bear a great deal of, I think, bolstering to the notion of government in particular needing to manage information holistically through a life cycle approach that takes into account that citizens are going to want proactive access to government-held information, as well as seek access, as well as protecting that information from a privacy perspective. We've also then got the domain expertise of FOI and privacy in the model. And one of the things that we've decided upon as a governance model is, whilst we respect the domains and decision-making of the FOI and Privacy Commissioner, we are governing the organisation as a collective responsibility with consensus decision-making around the way in which we decide to apply our resources. So always looking at the issue of what is the harm that we're seeking to address, and if we are going to open, say, a major investigation, that be done through the input and collaboration of all three commissioners.
And Janine, can I take you to the strategic review? And if you wouldn't mind also again sharing with members of the profession, what was the purpose of the review? What were some of the findings? And I know Elizabeth also has some comments about that. But that's quite an important milestone, both in terms of the future and the current practice. Do you want to share a little bit more about that?
So back in 2019, I was calling for a strategic review of the OAIC because it seemed to me upon coming into office that we really needed to look at the cohesiveness of the organisation in that time, what it looked like to have one commissioner model and how to be a contemporary regulator. We've had an evolution over that time with many new laws and programs to administer. We're administering about 37 different laws currently, where we have obligations to be consulted on privacy issues, be it telecommunications, national security and others. We've got responsibility for My Health Records, notifiable data breaches scheme, as well as specific legislation like the digital ID and also the consumer data right. So during that time, we've grown exponentially, and the demand for our services has grown. So we've had this opportunity, we've got some funding from government to really take a stock take of the organisation and conduct a strategic review. And the purpose is to ensure that we are positioned to be the kind of contemporary regulator that can meet the challenges of the future. And in a nutshell, what the review found was that we really need to accelerate our direction of travel towards more focus on enforcement and education, and in order to accelerate that, to uplift our ability to take that risk-based approach to regulation. So what that means is that you will start to see some differentiation in terms of the way in which we handle individual complaints, and it's about bringing to the work in a much more prominent way the issue of proportionality and making sure that we really are being the kind of regulator that is going to address the most prominent risks and harms for the community. And so I see that that's been a journey that we've been on for the last 6 years. And this has really given us authorisation in our operating environment to really accelerate that.
Right, that's a very clear mandate, yes, in terms of things. Can I just fast forward a little bit and really take Elizabeth and Kylie onto the journey of what does that mean for the priorities that you will now take forward in your respective portfolios? And I'm mindful, of course, that for you, Elizabeth, it's a double hat at this point in time. So can we get you to address what those priorities look like?
Part of the strategic review also looked at the governance support for the organisation so that it could make those strategic decisions in this consensus decision-making way. I want to commend Angeline and the organisation. We have a number of representatives of the organisation here today who have in earnest approached that through developing structures that will support and elicit this high-level strategic decision-making. So it was a real investment by the organisation, led by Angeline, to position Kylie and I for success. And that framework then sets us up with an ability to analyse with clarity the types of regulatory matters that we will prioritise, and also how we will exercise our regulatory functions according to what we're developing as 4 pillars of our approach, which go to proportionality, purpose, our people orientation. We're really very conscious of being purposeful in our action and impactful in our action. So the strategic review really recognised that in such a dynamic environment of change, digital government, the proliferation of technologies and the impact on human rights, how would we be effective? We need to set the foundation by way of guidance, by way of saying these are our statements about how we expect business and government to operate in this environment, and set that foundation piece from which we can then measure. And and on the way towards measurement as a way towards enforcement and greater enforcement focus. What the agency was able to do prior to Carly and I commencing is pretty powerful stuff, and I think we're really very much positioned to be able to deliver on those two outcomes that are going to be most impactful in this very dynamic regulatory environment.
There's a very strong theme emerging here about dynamic and proportionality, which is sort of very pertinent to privacy. Carly, do you want to elaborate?
Yeah, absolutely. And perhaps I can illustrate what this looks like in the privacy context from where I stand. So one really important thing to take note of is that the strategic review really recognised the changing regulatory environment in which we operate. And in the privacy context, that looks like vastly more interactions between individuals, entities, and the use of their personal information than there was 5 years ago, let alone 10 or 15. Increased public awareness and expectations of us as a regulator, increased public concern around privacy, and real, insistence that we act. And at the same time, more obfuscation of privacy-related harms by virtue of technology being the kind of intermediator between individuals, entities, and their personal information. And so whereas historically perhaps we may have been able to rely on individual complaints to rise up levels or issues of privacy harm to the regulator, increasingly many privacy harms aren't visible to individuals and require other kinds of regulatory tools in order to identify and then remediate them. So that's a really dynamic changing environment. It does actually require a big change, and that's what the strategic review set out to identify and to recognise. Going forward, what we want to see is compliance with privacy law. And compliance we can achieve through a couple of different ways, but two key ways. One is greater education of with regulated entities about what good looks like when it comes to compliance with the Privacy Act. And we have to go further, I think, than we've done before in articulating what that looks like, for example, in the context of different technologies, AI being the perfect example, of course. And then on the other hand, a stronger enforcement posture that really sends a message to the regulated community that if you're not going to comply, then we will certainly consider taking action where there are, in particular, persistent, egregious or systemic privacy harm. So we're really, and proportionality really underpins that. We want to encourage compliance, we want to aid compliance, but where there is non-compliance, we want to take action that both reassures the Australian public that we are taking notice and we're defending their rights, and also sends a message to entities that they need to invest in privacy compliance.
I think that's very clear. I think no discussion of our priorities will be complete without a good discussion about enforcement. And if I'm not mistaken, there are currently 3 matters before the Federal Court. I appreciate they're live matters, but they're all different but similar. Do you want to elaborate a little bit more on the enforcement posture and the role that taking action all the way to the Federal Court?
I don't want to. I'm very conscious that these are all matters that instituted by Angeline, so I certainly don't want to take credit for any of the matters currently afoot.
No, not at all. But behind them. Perhaps I can speak historically, and you can speak to the forward posture. We have got 3 matters on in the Federal Court. The Cambridge Analytica matter that was lodged in 2020. We've been all the way to the High Court and back on. Also Australian Clinical Laboratories and the Medibank matter, both of those are data breaches. And we've also had the benefit of legislative reform in 2022 after the Optus data breach, which gave the increased penalties that don't apply to those matters but will into the future of $50 million to align with consumer competition law, as well as increased information sharing powers that have allowed for that greater regulatory cooperation and cohesion. So I think what those cases represent are cases where we see it's, as Carly said, egregious harm, that they're serious and systemic, and they're intended to penalise and also to send a deterrent message to the market in terms of the need to proactively protect personal information. And if we look at the cybersecurity strategy of government, we're wanting to be a leader in cybersecurity by 2030, it's really incumbent on every entity to be making sure that they're protecting personal information, and these cases will give real jurisprudence around what it means to take reasonable steps to protect that personal information in this context.
Kylie, do you want to elaborate on that?
Yeah, I suppose going forward, these are the first three cases that will be seeing through the judicial process, and therefore we're going to learn a lot through that process, and including hopefully getting some law on the interpretation of various APPs. So that's a kind of enabling step towards further enforcement action. Going forward, then I think we'll be better equipped from a kind of legal basis to take matters. Secondly, the process of bringing these matters, and in particular the aftermath of the major data breaches in the last 2 or 3 years, has enabled the OAIC to invest in investigation capabilities, which we didn't necessarily have the resource for previously. So we now have, a maturing investigation cohort that again enables us to start to think even more broadly about matters we'll be taking forward beyond these three. And then finally, I think I certainly have a desire to think about what a strategic approach to enforcement action looks like in terms of coverage of the APPs and coverage of sectors as well. So how do we complement the work we've already done, in particular on APP 11 around reasonable steps to protect data, with other enforcement action that takes forward other APP interpretations? So
do you want to tell us a little bit more about the toolkit that you have? Because we've already heard, obviously, the precedent value of some of the outcomes of federal court action. But you're speaking much more broadly about the other types of intervention and reviews and enforcement activities that the office will avail itself of.
That's right.
Do you want to share that with the
So I think let's put to one side the Privacy Act reforms. I think we're going to come there because that will certainly even broaden our toolkit even further. The ability to seek civil penalties has only recently been added to our toolkit, so we're certainly very keen to exercise that in the way we have. But beyond that, I think we are absolutely aware that a proportionate approach to regulation means meeting harms with the right level of intervention. So that may be issuing a determination in a particular case might enable us to achieve the outcome that we're hoping for, versus seeking civil penalties, versus seeking to enter into, for example, an enforceable undertaking with an entity, and we've done that to great effect. And on the other hand, using other tools, for example, the media, speaking publicly, and using forms of public communication to tell a message about who we are as a regulator, the issues we're concerned about, and to encourage entities to engage with us from a compliance perspective on that front. So certainly, again, being driven by the findings of the strategic review about the need to be proportionate, but also proactive in how we address issues. We're thinking across a really broad spectrum about how we do that.
Without just going to the reforms, which we will go in a minute, what influence or what lessons are emerging from some of the enforcement from overseas and some of the cooperation work that's being done? And I know that that's an important part of the work of actually all of the commissioners in the OAIC. Do you want to speak to Cleveland? Maybe it's
before my time.
But. Yeah, sure. So we did do the joint investigation with the UK Information Commissioner's Office on Clearview AI, which was everyone's nodding, about Clearview AI. And the benefits of that international collaboration was, for the entity, a joined up regulator approach to them. So, and from the regulator's perspective, the ability to pool resource and intelligence around that investigation. I think more and more, of course, we're going to see the need for joined up regulatory approaches, particularly around artificial intelligence and other emerging technologies. One of the things that's been pleasing with the law reform that we received in 2022 was the change to the jurisdictional thresholds for bringing actions. So the carrying on a business test has been simplified. We no longer have to prove that the information was collected or held in Australia. And I think that is going to also enable greater global cooperation, but also greater ability to take domestic action around global entities.
And I would just add to that I think, Angeline hinted at the challenges of new technologies and their kind of cross-jurisdictional nature, and I think that the way forward on regulatory cooperation on that front looks like complementary actions to regulate in particular technologies or particular markets. So not exactly working together on a case, perhaps as we might have done, but choosing to come at a particular trend or sector or technology from different angles via different entities. So that, I think, increases the expectation of a higher level of collaboration with our regulatory counterparts abroad, and also a really creative approach to thinking about how to leverage the unique aspects of the Privacy Act as distinct from the GDPR or other legal frameworks, because I think even prior to Privacy Act reform, there are interesting things about our framework that we could actually leverage to take forward matters that other jurisdictions might be prevented from doing. So I'm very attracted to thinking really strategically and creatively with peers abroad on that front.
I know we keep saying we're going to talk about the law reform shortly, but I really can't avail ourselves of the opportunity to actually draw out some of those comparisons, but the unique aspects of the Australian law that actually will deepen with law reform. It's a question of how much and how deep. Do you want to say a couple of things about that?
Yeah, I think currently we have a principles-based framework that's relatively flexible and doesn't have some of the restrictive components perhaps that the GDPR has in terms of definitional factors, I would say. So I think there's a lot of scope there, and then some broad terms which really are subject to interpretation, and until we get some jurisprudence under our belt on that, we are relatively free, or there's a flexibility there for us to think about how to apply them appropriately. In terms of what the reform will give us, that will give us a lot. It won't give us a carbon copy of the GDPR, and I think that's a really good thing. Again, I think there's so much to be gained from a novel approach to data protection. In fact, we can learn from the experience of Europe over the last 6 years and some of the challenges in applying that framework. For example, perhaps the ineffectiveness of consent as a legal basis to genuinely grapple with power imbalances in the digital economy. And from that perspective, the fair and reasonable test in the Privacy Act review is a really exciting step to kind of exciting opportunity to leapfrog that approach and put the onus back on entities to establish fairness and reasonableness. So I think that's a really exciting element of the reforms. Other things that are closer to GDPR style rights, like the right to de-indexing, deletion, objection to targeted advertising, the automated decision-making provisions, those types of things, I think, there's a lot for us to build upon there in terms of Europe's experience, but I think there's immense value to be gained by harmonising on those fronts, and those are really important individual data subject rights that I think really will kind of enhance that aspect of our Privacy Act. So I think there's strength, as I said, in the current regime, and particularly taking a strategic and proportionate approach to applying it. I think we shouldn't, stop and wait for the Privacy Act reforms to come to think about how to continue to apply that against contemporary harms, but actually the reforms pose a lot of promise as well.
The broad discretion as well as broad rights. Elizabeth, was there anything from your perspective, particularly given the experiences that you've had in government and in administering the New South Wales regime?
I think the issue of this vastly different environment and what that means for the preservation and promotion of human rights, where we're dealing with global issues, and from an FOI perspective, an ability to go back to why the Act exists, what's the object of the Act, what is it designed to achieve, and moving from the transactional focus of an FOI application to its ability to, and its intention to actually promote democracy, to promote accountability and therefore integrity. In the Commonwealth context, we've got to move towards greater integrity, establishment of the NAC. We've now signed up for our third open government partnership, and the OAIC has played a leading role in the development of that partnership. But those initiatives really do take us up to this higher order purpose. That higher order purpose now has really crystallised in the face of mis and disinformation, and government information as being seen as a single source of truth that is oversighted by stewards who have discrete and very deliberate obligations around accountability, around transparency, around the service that they deliver in promoting information as a national resource, and also in supporting action that might be required in relation to privacy. So if we don't have this evidence, if we don't have this single source of truth within government, how do we take action? So promoting what the FOI Act is really established to achieve, which is a more responsive democratic system of government in which citizens are able to engage on the important decisions that are being made using automated decision-making technology or otherwise, but to actually engage in that as a lever to build trust in democracy, because the OECD research really demonstrates that Australians have a slightly higher than average trust in government, but the strongest lever towards that trust, or building block for that trust, is their belief that government will actually act on their input towards service delivery. But staggeringly, again, before my time, Angeline conducted the review of the information publication scheme under the FOI Act, which is required every 5 years. And that was published in April this year, I think. And we saw that 75% of agencies, and we surveyed over 200 agencies, were least likely to publish one mandatory category, and that mandatory category is the requirement to advise citizens of opportunities to consult in relation to service delivery. That's the lever for trust in democracy, and it was 75% of people, of agencies responding, we're not actually doing that. It's least likely to be published. So how we start working to achieve this higher order outcome is incredibly important. We're very well positioned. We have that data. We're drilling down and looking at agency practices now with an agency survey to build upon their needs, to ease their compliance, but to deliver open government for the Australian community.
So it's the trust and transparency connection. They're very strong connections if you're working in the private sector as well. And obviously we have a lot of practitioners here who are advisors to entities or agencies. How do we go about thinking about preparing for law reform and the changes that are coming? We appreciate we haven't seen draft exposure legislation. I know that there's been a lot of commentary. But in terms of the preparatory work, what would be the top things that we as advisors would need to focus on?
I mean, I think compliance with the existing APPs and the Act, any organisation that is on firm footing with current compliance will be on firm footing with the revised Privacy Act, or at least very far along the journey to do that. So I think we've have been encouraging advisors really to focus on that and considering holistically what good data governance looks like across the board. And again, any entity investing adequately in their privacy compliance is already doing that thinking. I think where the more challenging transition will be for those entities not currently covered by the Privacy Act. So at the moment, that's all small businesses. Yep. And potentially those whose business model sits at some of the crunchier points where we might say that the fair and reasonable test would start to bite on extractive approaches to personal information, for example, and that's where we might expect to see the OAIC looking in particular once the Act is, we hope, reformed. Having said all of that, we expect if and when the Privacy Act reforms are legislated, there will be a considerable transition period, and that our office will invest heavily in guiding and aiding entities in making that transition and understanding what compliance looks like under the new framework. And we don't want anybody to be caught unawares, and it's not a gotcha moment. It's certainly appreciating that it is an uplift that organisations are going to have to take, and the regulator has a big role to play in that.
Yeah, so the office sees a responsibility for
Absolutely.
education, transition, and
Absolutely.
dealing with some of
And
those.
I think the Privacy Act review prescribes in excess of 20 areas of new guidance that we'd have to develop, not least of which would be the Children's Online Privacy Code, but also updating all of our existing guidance and materials would be part of that process too.
And did you want to expand a little bit on that very delicate balance in digital economy? I know we've got vulnerable data subjects like children, but what about the broader community and sort of information asymmetry, and how do we think about that in preparation for changes, given the complexity of technological change and lead-in times?
Yeah, I think it's going to be a period of adjustment for everyone, including for us as the regulator, as we understand how these new technologies run up against the legal framework. And I think we're relatively new into that process of really looking at, for example, generative AI models and understanding how they use personal information, how we might consider the principles of the Privacy Act applying in that field. So I think it will be a period of us feeling our way, and equally, I imagine, regulated entities also seeking to understand. And that's why I think there's an additional responsibility incumbent on us going forward to really try to articulate what good looks like. So not least because that is the best way we can support entities to use technology positively and consistently with their customers' expectations and with citizens' expectations. So again, that's a kind of new and additional responsibility that we'll be taking on as a regulator.
And a bit of a question actually for all three commissioners here. Do you see that regulatory convergence, the work that ACMA's doing, the work that ACCC is doing, fitting into that transition and a building block? Or what's the thinking around how do you deal with convergence as well as the regulatory change in your distinct area of responsibility and the laws that you administer? Why don't we start with you, actually?
All right. I think I've spoken a bit about regulatory convergence already, and one of the things that I've seen during my term is the significant convergence between consumer competition and data protection law, but also the complementarity of that and the need for both separate regimes. So ensuring as regulators that we're using our regulatory toolkit to work in the public interest, avoiding duplication, but also using our specific tools in the ways that only each regulator can do. And I think from a consumer competition perspective, it's really about the relationship of individuals and the asymmetry in markets. In data protection, it's a similar informational asymmetry, but it's about protecting that human quality of autonomy and dignity in that context. So how do we bring that to bear in our regulatory environment? I think I've mentioned before the Digital Platforms Regulators Forum, that where we meet. We have, it's really an administrative body of the ACMA, eSafety, OAIC and ACCC. And we are looking at regulatory convergence. We're looking at large language modules and AI and how our respective domains come to bear. We're also working with cybersecurity regulators, with APRA, with ASIC, with the ACMA around cyber and data breaches, ensuring that we're sharing intelligence, and also, again, making sure that we've got a cohesive approach to the regulated community. So from my perspective, that's been a really important step forward to create greater cohesion for the regulated community, but also to ensure we're really optimising the resources that we have as regulators.
Elizabeth, do you?
I'd just like to echo Angeline's structural outline by way of intent. So in doing so, in undertaking this collective approach, we're actually better meeting community needs. So I think we see that within the OAIC, but we're seeing it more broadly in regulating, particularly in the tech sphere. We can't have a compartmentalised approach to some of the harms that we're seeing. So bringing together both the statutory regimes as well as the expertise of different regulators is actually providing more of a holistic solution to these harms.
And Liz, just thinking about that from the access to information perspective and government regulation, that we have that joined up approach in terms of collaboration with the National Archives Office,
Absolutely.
with the Commonwealth Ombudsman, and I mentioned before the National Data Commissioner, to ensure again that our collective concerns are known and our differential abilities to address them are coordinated.
Very coordinated.
I don't have
Was there
anything
any? No,
further
that's
to add.
very comprehensive. If you wouldn't mind indulging me, we're drawing to a close. We've had a very comprehensive discussion, and there are very, very strong themes emerging about collaboration, harmonisation, and proportionality. Big words and big concepts, and obviously for regulators, a very tall order to deliver to. So we appreciate the challenge. Can I ask each of you to address the question of if you could change anything in your remit as a regulator, what would you change and why? Maybe we start with Angeline.
Thanks, Olga.
Pleasure.
This is a hard question because there's three remits, isn't there? But I'm going to focus on the digital economy, and if I could change one thing, it would be to have a licence to operate for data-driven business models and also for those who are using high-risk technologies. And I think we have steps towards that with accreditation requirements with digital identity and consumer data right, which really gives the community assurance that those who are operating in that system have the right protections in place. And I think that the privacy reforms around fair and reasonable take us along the path to that objective, as well as requirements to conduct privacy impact assessments.
Very comprehensive. What about if we move to Elizabeth? What would be your wish list change and why?
I think the journey from transactional in FOI to embracing the intent of the Act is one that can't be neglected in any way. It needs to be constantly stimulated and vigilantly monitored. And it requires engagement with the community. That's the compact between government and the citizens they serve. It requires engagement with agencies to build their capacity and actually make compliance easier, telling them what better practice looks like, ensuring that their systems support both the objective of open government but also the transactional piece, and to elevate also the OAIC's ability, which we're doing very well, towards being a contemporary regulator, which means that we can't look at historical cases and expect to be effective in the extant regulatory environment. So we need to deal with our historical cases. We need to grab the intelligence that we will find from complaints and IC review applications about the current regulatory environment and the risks and harms in that regulatory environment to take us to being that really effective regulator across information access and privacy. So just as in the privacy domain and the information access domain, there's been these external forces, internally, within government, there are forces as well, and we need to better understand those and address capability, lift that capability within government to achieve that higher order purpose. So the ambition is one of change over time towards a culture of open government.
Okay, all right. Carly.
Where do I begin? I suppose, I mean, I don't want to be the regulator asking for more resources, but I would say that what I would like in an ideal world would be an unlimited litigation fund. And not only because, not as you might expect, just to enable us to, take enforcement actions all over the shop, but rather, I really think that a principles-based legal framework like the one we have only evolves with judicial interpretation, essentially. And we've seen that with the GDPR. It's 6 years in, and we're just starting to understand how it bites on various data processing practices. And I think the same is true with the APPs. So in an ideal world, we would build out the jurisprudence around every single APP with multiple enforcement actions. It's not going to be the case, but that would be my dream.
Right, I think we're all for a very busy time here. And
to be clear, we do not
To be
have
clear,
that.
yes, to be very, very clear. So my last question to the three of you is a little bit more retrospective looking, given the nature of what we're discussing today, is what would be the key achievements so far? So, Angeline, let's start with you.
I'd have to say elevating the national regulator on the global stage in data protection and access to information, and utilising that for the benefit of the domestic economy and government.
I think a lot of people would echo that, given the international footprint.
I have to start with data, but it's
Start
through
with
a very
data,
different
okay.
lens. The key achievement for me is actually being able to bring home the work that precedes me. So we concluded the 30th of June, of which I was only there for about 4 months, so it's definitely precedes me, with 3 times more investigations, so we conducted more investigations threefold than we had previously. We issued 207 Information Commissioner reviews. That was 3 times the previous years. We closed down aged backlogs in complaints, so now our complaints are only 18 months old. And we finalised 15% more IC reviews, notwithstanding a 7% increase. Now, this might seem in isolation just a set of great figures. We need to think about what precedes me, and that is year on year, all but 2 years, the OAIC has received increasing numbers of IC reviews, and many of those have been deemed decisions. They literally come to a house of review, which is what we are, as an original decision because the decision has not been made. So these are significant decisions, and the average over the last 8 years, I think, Angeline, has been a 12% increase in the volume. So to be able to deliver this sort of outcome and to recognise the work that has gone on absent additional resources is really quite an extraordinary achievement, but it is not my own. It is that of the OAIC's and Angeline's.
Thank you. No pressure, Carly.
Oh, I don't think I can claim any achievements yet. I'm only 5 months in. I would say if I'm still kind of learning what the job is, to be completely honest. But if I can say one, gratifying change that I've seen starting to emerge is perhaps in my interactions with my colleagues at the OAIC, I'm seeing some really creative ideas come forward about how to resolve matters or take different approaches. And I think that, that to me is the sign that this learnings from the strategic review are starting to bed in, and we're slowly moving to a slightly different approach.
So that's a kind of incremental change.
I think so.
Yeah, that's consistent with what's to come. Really, it's very easy for me to sum up: proportionality, precedent, and preparing for change. But really, in preparation for change, I want to give the last word to Angeline to close the seminar today, and then to move to a more informal discussion. Angeline, the floor is yours. Last remarks, closing remarks.
Thank you very much, Olga. Well, first of all, I'd like to thank the Law Council and the opportunity that the Law Council has provided me over the years to speak with practitioners. I also want to thank the Law Council for its leadership on data protection and information access issues, and I remember public hearings back in 2018-19 on information access issues and many on data protection since that time, where I've seen the mutual respect of all sides of politics for members of the Law Council who appear, and to congratulate you in the role that you play in upholding the rule of law. So thank you. In terms of the conclusion of my term, it has been an honour and a privilege. You know, I'm really honoured to have been able to lodge the first civil proceedings in federal court and to take the organisation on a trajectory that means all of our enforcement powers will be utilised. I'm privileged to be able to conclude, as I said, with 3-commissioner model in place and to see how that model will really assist the Australian community into the future. So I'm leaving at a time of great excitement, I think, anticipation and promise for the OAIC, for regulated entities and for the community. So thank you very much.